Morning everyone, and I hope you all are doing well. I am Dr. Meghraj, and today we will discuss the remedies for misrepresentation or untrue statement or misleading statement in the prospectus. See, the very purpose of the prospectus is to give the information to the public so that public can make the prudent decision while purchasing the securities. But business community use the flattering and the extravagant term that are not true and sometimes misleading, sometimes deliberately they omit some term so that the potential purchaser decision would be affected. Here, for the remedies of misrepresentation, we can divide that remedies in under two heads. One is the civil remedy, another is the criminal remedies. Okay, then the civil remedies also can be divided under three heads. One is under the law of tort, second is under the law of contract, and third is under the Companies Act 2013. Now, under the law of tort, there is the tort of deceit, and so the damage of the deceit can be seen if any person on believing the statement that true in the prospectus has acted and suffered the losses. So for recovering that damage by way of compensation can sort these damages and of the deceit under the law of tort. Second is under the law of contract. Under the law of the contract of the allotment of the securities can be rescinded, and then for the damages it can be under section 75 action can be taken. The third one is under the Companies Act 2013. Here there is the section 35, and this section 35 has the genesis from our the company's decisions in Dairy versus Peak, when the House of Lords has not made directors liable for the misleading statement in the prospectus, because House of Lords said that they has the honest belief, and so in the Britain, the Directors Liability Act 1890 was enacted. Here we have section 35, and section 35 says that if there is any untrue statement, if there is any misleading statement, if there is any omission of the statement in the context it is used, and by which a person has acted and suffered the losses, because it is civil remedy only, it is applicable when the losses are suffered, not when the losses are not suffered. In that case, every person's first the director, any person whose name is shown as the prospectus as the director, the principle of holding out, and the third one is the promoter, then the fourth one is any expert would be liable for the damages by way of compensation. But then there are the exemptions, and the exemptions are like if the director has shows that he has no knowledge, or it was issued without his consent, or it was issued when he left the as the directorship. In that case, it would be that person would not be liable. Then we come to the criminal remedy. Under the criminal remedy, we have two major sections, section 34 and section 36. Section 34 says that if there is any true statement or misleading statement in its form or the context where it is used, or misrepresentation, in that case the person would be liable under the section 447 of the Companies Act as the fraud. Okay, but if there is even the belief is there, that honest belief must be founded on any reasonable ground. And section 36 is talking about if any person the forecast, if any person make the statement that is misleading or omit any statement by which the person that amount to the misleading statement while making the agreement for the subscription of the share, etc., then also the person would be liable. So by these two remedies, civil and criminal remedies, the court and the law want to suppress this type of the tendency. But the question raised that the words used like the untrue or a misleading statement, what is their meaning. See, the untrue statement means any statement that is used in the form and the context. If that is not true, then it would be untrue statement. In the context it has to be shown, not only in the form. In R versus Dislant judgment, it was held that the company made the statement in the prospectus that the company give the dividend to the shareholder from 1911 to 1927. That was true, but they have omitted that from 1921 company suffered the losses and the dividend was given from the wartime profit. So this statement they have omitted, and the court held that this is also the untrue statement. Now, misleading statement representing the fact in such a way that it gives the different meaning. Now here there is another issue, that if this is the liability, civil and the criminal, then how to draft the prospectus, and for there is the golden legacy or the golden rule, and this golden rule has been first propounded by Pagewood in the Henderson versus Lincoln, and in this judgment it was held that very strictly and scrupulously it has to be drafted. There should not be any word that give the wrong meaning or that mislead the general public. So with this golden rule, a prospectus has to be drafted, otherwise there are the remedies available under the civil law as well as the criminal law. If you got any legal education from this document, please like the video, subscribe the channel and press the bell icon button, and please write the comment if you want more video on any other legal topic. Thank you.